Good evening and welcome to the Thursday, June 26th Oregon Public Defense Commission work group meeting. We are here with a few commissioners to discuss a few items on our agenda. But before we get started, the first order of business, and we only have three other commissioners here, but the first order of business is to introduce our newest member of the commission to the commissioners that are here. And it's Knab, right?
It's NAB.
Nab. Okay, I will remember that now that you've told me. If you can just introduce yourself, that would be great.
Absolutely. Thanks so much. I'm really excited to be here. My name is Philippe Nab. I'm actually coming to you today from a Holiday Inn in Yakima. And that's relevant, actually. That's relevant because in my day job, I am the eviction defense and reentry program director for the Washington State Office of Civil Legal Aid. And in that role, I oversee a statewide right to counsel for low-income tenants in Washington State. So I'm here in Yakima today because I am participating in a statewide small town and rural practice summit in Yakima, Washington. In my day job, I deal with a statewide appointed counsel indigent defense program. But that is not my only experience in this area. I've worked as a public defender in the South Bronx, at the Bronx Defenders for 7 or 8 years, and spent most of my legal career, almost 20 years in practice, representing low-income folks in either public defense or civil legal aid. So what I'm hoping to bring and what I'm really excited about doing is bringing some of the kind of what I've seen work and not work in New York, where most of my career is, and here in Washington, to kind of deal with what is some very real issues in public defense in Oregon. And I'm excited. I should have started out by saying I live in Portland, so I'm really excited to contribute to where I live and be a part of that. I will say also that I think I certainly bring strengths in terms of the depth of practice and best practices that I've seen, things that I've seen work and not work in other jurisdictions. And certainly I'm going to need some help from the Oregon perspective because I've never practiced law in Oregon. I am admitted to the Oregon bar, but I've never practiced in the state. So I'm super excited. Just to kind of round out introduction, in addition to working at the Bronx Defenders, I was a supervising civil rights prosecutor for the New York City Commission on Human Rights. I also worked as a managing attorney for the Northwest Justice Project, which is a civil legal aid provider in Washington State. So I have a lot of experience in direct services. I'm excited to bring it to bear. I guess the last little tidbit is I'm from Mexico originally, but I grew up mostly in upstate New York. So it's nice to meet you all. I'm actually really, really excited about this work, and I really do believe that provision of public defense is, even beyond the rights, it's an amazing opportunity to address society's wrongs. It's an amazing place to be able to intervene in people's lives and make positive outcomes. And so I really do think that building and having a strong public defense infrastructure is, essential to civil society. And so I'm excited to be a part of it. And I know we have some heavy lifts, and I'm excited to be a part of that. So thank you.
Well, thank you. And this is our small informal work group. And so that's why there aren't very many commissioners here. You'll have to do your introduction all over again in the big in the big meeting that we have in a couple of weeks. But you know me, I interviewed you with the executive director and vice chair. So I'll just skip over us and have Commissioner Harris-Robb introduce himself.
Good evening, Philippe. Really glad you're on board here. Nice to hear a lot about your background. It sounds like it's going to be a really good fit, and I've heard nothing but good things about you. I've been an attorney here in the state for almost 40 years now. I quit practicing a couple of years ago, but I did a lot of public defense work, but not solely public defense work. Also started the nonprofit consortium in Washington County, so I managed that stuff as well. I was appointed to the commission 18 months ago. I think that's about right. Yeah, 18 months. It was a largely newish commission, I guess, 18 months ago. So a lot of us are pretty new to this, other than Jennifer. She's been on it and been our leader, our fearless leader for the last 18 months at least. So glad to have you on board, and I look forward to working with you.
Nice to meet you, Rob.
And Steve, you want to introduce yourself?
If I can come off mute, I'm usually much more adept at this. Hi, I'm Steve Art. I am the manager for the Trial Support and Development Division. And what my lawyers do is they do a lot of the performance monitoring for folks that we contract with. And tonight we're going to be looking at the attorney qualification standards that we've drafted, and hopefully we'll clarify some areas where maybe it's not clear. We'll come to some conclusions about some areas where we may have some disagreements about where we should go and make a way forward.
Sounds
Great.
great.
Well, really nice to meet you, and I'm excited to be a part of that.
Well, I want to be mindful of the time because I know Susan has to leave at 5:30, and Rob, are you also at 5:30? Yeah, okay, and Ken is at 6, so that'll just.
I'm leaving at 6, Jen.
Okay,
Yeah.
all right. So I want to just address before we move on to the attorney qualification standards piece. House Bill 2614 passed both chambers, right, Ken? Yesterday. Yes, okay. And so it is going to be presumably, there's no reason to believe it wouldn't be signed by the governor. And I'm just wondering, I know Lisa Taylor sent an email out to all of us about that, and I'm wondering if there are questions or if we want to discuss anything. If not, we can move past that. But go ahead, Ken.
It was passed by the House today. Sorry, I thought of our budget bill was fully passed, but yeah, 2614, the amended version from the conference committee went to the House today. It was passed 44-9, and so then it should go back to the Senate for the final vote.
Okay, great. Senator Prozansky really shepherded that through, although Representative Evans, who's also on the commission, was also part of the conference committee. And so everybody worked together as conference committees work and came up with the compromise. So if there's any questions about that, we can talk about it. If not, we can just, I had it on the agenda thinking that we weren't sure where it was going to be in the process and people might want to talk about it or ask questions. But for just, I guess, just for the general public too, just briefly, the sunset provision of the consortia elimination that is gone, or actually it's 2033, and there's a specific provision that puts subcontracting back into the law, so consortia will remain. There are governance pieces related to consortia. In order to be eligible for contracting, there are certain things that consortia will have to, certain requirements consortia will have to meet. The executive director can be terminated, removed by the governor for just cause, which is clearly defined, well, as clearly as appellate law can define anything, clearly defined by appellate law. If the executive director is removed, the process for reappointment of the executive director is in consultation with the commission. Governor appoints subject to consultation with the commission and the Senate has to confirm. Commissioner, the language regarding removal of commissioners remains as is. So that language has not been changed. It remains, commissioners can only be removed for malfeasance, neglect, and something else that I always forget, but basically you have to do something really wrong. The commission is completely under the administrative authority of the governor now. We were in kind of this weird hybrid situation where some things we did when we moved to the executive branch, some things we did like executive branch agencies and many things we didn't. So now everything's going to be like other executive branch agencies. And The commission itself can no longer advocate for legislation, but of course, individual commissioners can advocate for legislation on their own behalf. And have I missed anything, Ken, that you can think of?
No, I think you hit the highlights. And then the piece that you could not remember for removal, it's malfeasance in office.
Malfeasance, right? Something really bad, malfeasance. All right. Okay, so that's where it ended up. And it'll get signed, and hopefully that'll put the governance piece, the tinkering with the governance piece at rest finally, and we can move on to and continue to work on the things that we need to be working on. Any questions about that or comments or, okay, great. Then let's move on to talking about attorney qualification standards, just to refresh everyone's recollection. And for you, Philippe, we had the attorney qualification standards presented to us in a briefing in June, and there were questions, which is kind of the way it goes. That's not surprising. And then we talk about the questions in work group either before or after they're in an official commission meeting, get any kinks worked out, any questions commissioners have, and then they come back for an action item in the subsequent month. So I expect to see these back in a couple of weeks for approval. So there were some questions about the impact of these on the current workforce, and we wanted to have a bigger, broader discussion about what to do about the current workforce in terms of right now, qualification standards are tied to tenure, so length of service rather than skills. And we're really agencies trying to shift to qualification standards to be based on demonstration of skill set rather than tenure in doing certain kinds of work. So the question then becomes, what about the current workforce? How do you map that? And what's the impact on the current workforce if you change the standards? Because we don't want to lose people, obviously. We don't want to also leave an impression that a person who's been handling a certain type of case may not be able to handle the cases under the new standard, because that raises some issues as well. And so there were some questions and some concerns about that. So with that, I'll turn it over to Steve to kind of pick things up.
Thank you, Chair Nash. So the idea of the new standards is that folks would be sliding over from one qualification to another. And for the most part, nobody is affected. However, I did find that J-law cases are moving up. So where J-laws are now in with the Measure 11 cases and major felonies, they would move up onto a peer level with murder cases. We're going to have to draft something that says that nobody's going to lose qualification, nobody's going to lose their cases. It doesn't make any sense for people who've been doing this work and they've been competent at it and they've been capable for them to lose qualification. So the next question becomes, if we do a recertification, we've been talking about doing recertification every 3 years. The same year that your MCLE report is due, you would report back. We've got a couple of ways we can do that. We could say that once you've met your minimum qualifications, if you continue to practice, you continue to meet those qualifications. Absent any sort of, something really bad, you've mishandled cases, you're no longer capable, you're no longer competent. That's one way that we could do recertification. We could require that at some point you've met certain standards. What I think we don't want to do is say that you have to have had so many trials in the last 3 years. You have to argue so many of this kind of motion, so many of that kind of motion. It's way too specific. And I couldn't pull data on how many lawyers we would lose if we did that. It was just it was a data nightmare to try and get a statistically significant sampling. Instead, I did kind of an informal straw poll, mostly talking to rural providers, saying, how would this affect you? For them, definitely a system where once they have been certified, they remain certified makes the most sense. They just do not have the opportunities, especially in these more serious cases, to continue to do them in the jurisdictions where they practice.
Yeah, I think that makes a lot of sense. What do other people think about that? I think it saves a lot administratively too.
Hmm.
So you don't have to, every time. Go ahead, Susan.
Well, I remain concerned, as I said at the meeting, that we need to have something that makes it very clear that if someone stays in practice at a certain level and does not meet the new qualifications, they're not vulnerable to post-conviction suits or civil suits questioning their competence because they don't meet the current standards. There has to be something that indicates that the current standards are not measures of competence for either Sixth Amendment purposes or for tort purposes, because otherwise I think we're going to end up seeing challenges along those lines. And I'm not sure how you finesse that. If we're saying that these new standards are skill-based and the other standards were not skill-based, I it maybe I'm being overly paranoid, but it concerns me.
Well, what if you just slid people over? So if you've been taking major
Mhm.
felony cases, you're major felony qualified, and that's it. And
Mhm.
just full stop. That's where you start. And then if you want to up qualify, then it's skill based. So,
Right.
I think that what we might have to say is if you've been taking cases at X level, we consider you qualified to practice at X level. So these
Mhm.
standards are for people who newly want to be at that level. But I think we have to say that in so many
Okay.
words.
yeah, no, I agree. I think that makes sense too. And if you're like minor felony qualified, and then you want to be major felony qualified, if you're minor felony qualified now, you'd slide over. And then if you want to bump up, you have to meet the next level of skills.
Yeah, exactly.
I-
But I don't want to
Mhm.
use the word slide over. I want to
yeah,
say,
yeah,
Right.
I,
understood.
I want to say if you are doing those now, we
You remain
consider
qualified.
you are qualified to do those. Yeah, thank you.
And I think it's important that we recognize that attorneys who are qualified under the 2019 standards are qualified. They are competent, capable attorneys every day representing clients. This does not mean that they are anything less than what they are today. I did check into whether there has been any sort of PCR, ineffective assistance to counsel, ever raised based on qualification standards in Oregon, and it doesn't sound like that's ever been something that's come up. But to your point, perhaps with new standards that are different, somebody might say that we could certainly draft language in that that addresses that.
I think that's great. And I think your idea about once you're qualified is a
Mhm.
really good idea for lots of reasons. I mean, just practically speaking, it makes a whole lot of sense. And then, of course, as I said, from the administrative standpoint, it just makes sense too. You just have to sign something that says, yes, I continue to be qualified, and I've taken the CLE credits that are required or whatever, and
Mhm.
I'm good. Yeah.
Right. At the current level of staffing, we would be reviewing 350 recertifications a year. That's a lot. And if we have to go in and check, okay, how many trials did they have? We would have to go in and it would be a lot.
Rob, do you have any thoughts?
Um, uh, One observation, I heard Steve say earlier that the one area where there may be some issues with mismatch between new qualifications and current practitioners is in J-law, lawyers doing J-law cases. Is that right, Steve?
Yes, yes.
And the comment was, we have several who've been doing J-law for a while. They've been doing a good job, but they don't meet current certification or the current new standards.
Then, right, the
I guess
2025.
my question is that maybe those new standards are too stringent,
Yeah,
because if they've been doing that work quality wise for a period of time. So I'm not saying change it, but it's just an
Yeah.
observation based on what you just said. And then secondly, I'm sure someone's going to file a PCRC, so-and-so doesn't meet these standards and they were grandfathered in. So I think it is important how you state this, like,
Mhm.
we want them to be highly qualified. These are our new standards, whatever.
Mhm.
You could do an individual review of everyone that didn't meet the current standards to make sure they don't have like 25 PCR cases and bar complaints, without being an automatic. So there could be a little bit of a review. But then it becomes sort of subjective too. And I don't particularly like that either. That's just some thoughts, but I think the work is important. I think we have to
Mhm.
do it. It's going to take some time, but it's part of our quality control. And given the way we have a delivery system, since we don't have 90% government lawyers who have more oversight, it's just something we have to do.
Susan?
So I'm
And
gathering from this discussion and from the discussion at the last meeting that the main reason we're doing this is for administrative convenience. We have no concerns, if I understand it correctly, about the competence of lawyers who are currently doing public defense work under contract to OPDC.
Yeah, we're doing it because we're statutorily required and we've not done it.
Okay, so
before.
we're
And yes,
statutorily
that's right.
required, but my point is that if there were some kind of preamble, in addition to everything we've already said, if there was some kind of preamble saying, we have no questions about the current competence of people doing public defense work under contract to OPDC, these new standards are being adopted because of legislative requirements and for our administrative convenience. If there was some kind of a preamble that said those things, that would at least move that discussion to a different level, I think. It would be just an extra level of clarification.
I agree, but I don't think the administrative convenience should be in there, just because it's not. We're doing it because we substantively need to do it and we need to have qualification standards. So I don't want to leave the impression that we're not taking it seriously either.
Yeah.
But I think we all understand the point. We need to just make sure that we're protecting the current workforce.
Yeah, so saying that we're not doing this because of doubts about the current workforce, I think it's
Yep.
to say that, yeah. Okay.
Philippe, do you have any thoughts? Because you've set up programs, you've done this before.
Yeah, I mean, we relied heavily when we did this in our current program on current practice standards promulgated by the state bar and by the ABA, and so there's still a lot of context that I need about these standards specifically. So I feel like I'm trying to pick up, and I will certainly get up to speed on it, but I mean, I think to the extent that these are codifying what's already in place. It's important to state that, right? It is, I think it's important to understand it both as an accountability piece in the future, but also, something that we don't want to make what is a very difficult workforce, difficult job and a difficult arena to find qualified attorneys more difficult. I'm reminded of when staff was asked to take a test for language competency in that they'd already been exhibiting for several years in a nonprofit I was in, and just what it did to morale. So I think we certainly want to stay away from making people prove something they've already proven in their practice over and over. So I think everyone's saying, and I'm certainly going to get more specific context as we continue the conversation.
I think that's a really good point. And one of the, I was, as you were talking, I was thinking about my law partner who is not currently taking any court-appointed cases, but had a one of the enhanced hourly rate cases, and he was winding down that case and knew that he was going to sentencing on a murder case, and he was up against the April 1st deadline that was set to kind of qualify or recertify, and he was super annoyed about having to do that because he knew it was like his sentencing was like April 15th, and he was like, this is so stupid. I'm already on this case. Why do I have to do this? And so he was, and I was like, dude, it takes 5 minutes. But I understood the frustration. I mean, it makes sense. You know, I started thinking about that when you were talking about how annoyed he was about that. And we don't want to do that to our entire workforce. That's absolutely right. Rob?
So I think that's a good point. That as far as promulgating standards, we're not the Oregon State Bar, we're not the Supreme Court. We're doing this as a matter of contract, not as a matter of setting professional standards necessarily. And we sort of are, but it's because the legislature told us we needed to do this. But also, it says if you want to enter into a contract with the state, because there's a lot of, I'm sure, private bar lawyers who don't meet these standards that are taking these cases, and they're not going to be PCR'd because they don't meet these standards. You know why? Because this has nothing to do with what a court thinks is qualified PCR. It's just a matter of contract. And so this is a
That's a good
contract
point
number.
too. Yeah.
So
That's
I
a really
think if
good point.
we indicate, like you said, Jennifer, this is a matter required by statute in order to enter into contracts, and therefore this is what we came up with for our contracts. Hourlies, I guess, are also contracts, obviously. And maybe having a waiver system for that at the discretion of the director would be good, particularly if it's hourly, like for your partner there, you know, to waive that. I don't know. That's another issue though. But to address the issue for today, I think if we address this as a matter of contract and statutory requirement, I think that may be a way to address it.
Yeah. All right. Any other comments or questions?
Yes, I have one question, and I think this is mostly for Steve, but you know, I certainly understand all of the reasons that we're talking about this in terms of and in light of the the burden on present contractors and the folks that are already doing the good work. But in terms of its future utilization for accountability in these areas, what is any of this language or any of the proposed changes something that might make it harder to hold someone who's not meeting those standards to the standard practices?
Well, the new practices, the new qualification standards require, for example, at certain levels, you're required to have a certain number of trials. You're required to have perhaps argued a certain number of motions. My concern is, and I think others have voiced this concern, is when we start getting into providers who are maybe just in a situation where they can't get a trial. Maybe there's a backlog in the courts. Maybe they're in a jurisdiction where you just don't have a lot of major felony trials. We have some ideas about language around that where we can talk about comparable experience, and those sort of things. At the same time, I want to be very careful that we're not being too liberal in our standards, and that it becomes very subjective. And we say, well, yeah, this kind of looks like, sort of looks like, and then we could have inconsistencies in who's getting certified and who's not getting certified. I certainly don't want to have any disparate outcomes.
Contrary to that, I would say that we've got ourselves into a corner by having really high standards because we think we're trying to please people, and trying to get some policies that we believe are valid over the line. And in some instances, it's at least contributed to the crisis we're in. So I think we have to be somewhat smart about what the real world status is as well. So I think we may adopt it, but I think we should maybe consider it a work in progress as well.
Yeah, that's what I was just thinking when everyone was talking, is maybe we're just not ready to move forward in July. Maybe we just need to keep working on these. And I mean, tell me what you think about that, Steve. Is there a sense of urgency about needing to have these done?
As I understand it, we come back to these in 12 months. And then we come back to them at 2 years, and then we have to come back every 5 years. I think this is an executive branch thing that somebody was explaining to me, and
I
that
don't know
seemed
that, so.
that seemed really reasonable to me. Because then you've got 12 months to live with something and say this works, or oh my gosh, what was I thinking when we signed this? And then you've got another year to continue to refine, and then every 5 years thereafter. And there's nothing that stops us from changing standards at any time. You know, we found that this standard doesn't work. We're going to make that change. Obviously, we want to get the best product out we can. We don't want to have a product that's half baked.
True. I also am cognizant of having having the standards change for the workforce. I mean, we hear all the
Mhm.
time, like little things like you keep changing the name of our forms and I don't even know what it's called anymore. And that's a tiny little thing, right?
Mhm.
So when
Yeah.
you start talking about changing standards every, a year, then 2 years after that, that's a lot in a 3-year period of time.
Mhm.
So I'd rather wait and make sure that we have it the way we want it than to say, well, it's okay, we can pass it and change it in a year. Also, I've not heard, the commission generally hasn't heard that timeline, so I'd be interested to know where that comes from. I can see Ken's brow furrowed, so maybe he's trying to figure it out while we're on the meeting. Rob?
Yeah, I like that idea actually as well. Is there a way we could like say we're requiring under this new contract that your qualifications be reported, but we're not enforcing these standards at this point until we see this data and we see what the pushback is? Or at least we see what the issues are. Maybe that's not the right way to do it, but at least we'd start actually getting data from people, I guess, as a matter of contract obligation. Two other things, because I do have to jump off. One, Philippe, I wanted to ask you this because I heard you pronounce Yakima, Yakima, and I grew up in Washington. We always pronounce it Yakima. Am I pronouncing it wrong? Did they change like they do the Sacagawea to Sacagawea, or what's going on there?
I would go with your
Okay.
pronunciation. I've been here for 5 years, but Washington has a handful of places that I'm still working on the right
You
pronunciation.
got, yeah, Tulala, Puyallup, a lot of those.
Ponderay is the one that
Oh,
I
yeah, that's a good one. All right, and then the second thing, I have to hop here, but to be continued, let me know what happens. This is a real interesting and it's an important thing we're going through. You're right, Jennifer. We need to get this right so we don't reduce capacity as well. Thanks.
Susan? You're muted. Susan, you're muted. We can't hear you.
Yeah, Steve, when Jennifer said, is there some reason we have to do this in July? And then you talked about the 12-month, 2-year, 5-year thing. I'm still not clear on whether we have to do this in July.
I don't know that we do.
Yeah,
I mean,
so
we'd like to have them before the new contracts, but I don't know that that's a need to have them before
the
the
new
new contract.
contracts are coming up really fast, right?
Right, the extensions are out,
Yeah,
and then we've got 90 days from June. would be the
September
new
30th.
contract. September
Yeah.
30th.
if we put it off, if we put the action item off until August, what would we do in the interim to move things forward? In other words, what activities would we undertake between now and August that would give us more clarification about whether the standards are ones we want to adopt? Would we have work sessions with providers? Would we have more studies done of standards
Well,
and other, I mean, what exactly would we do that would change the playing field between July and August?
As drafted, these are very heavily relied on the provider community. I don't know that working more with the provider community in drafting would necessarily be helpful. Maybe something more akin to a notice and comment rulemaking where, here's what we're considering. What are your concerns? That might have more value.
Kind of like we did with the question and answer piece for the last commission meeting. Maybe we just put them out and ask people to comment on them and give feedback.
And do written feedback and not
Yeah.
oral feedback.
Right.
Yeah.
And see-
I like that idea because just putting it off so that we can mull it over in our heads doesn't strike me as useful or efficient. But if we gave anybody a chance to weigh in writing, that would give us more information. The question is, whose job will it be to review the written submissions?
No,
I don't
way
want
that
to put more burden on Steve, who already, I imagine, has a pretty full plate.
So I think that if the commission is soliciting input, it needs to be the way it has been with other commission solicited input, specifically that it would go, it would be appended, it would be publicly, it would go to me, it would go to staff people, go to the whole commission, and it would be on the public website so that everyone could approve it. I don't imagine, I could be wrong, but I don't imagine we're going to get 150 comments. I imagine we're going to get, the usual people that take the time to comment on things and do a deep dive into them. So maybe 10 or 15 comments, and they probably will be about specific provisions, not the whole thing. I think,
Although if they've been paying attention, they may have some comments on the bigger considerations.
Ken, what do you think about that? Soliciting just input, kind of like we did for the question and answer session in the last commission meeting.
I like that. I mean, I know that Steve and his team have worked with a panel of folks, and so we've received a lot of input, but that's a smaller group. And so I think opening it up to the community would be a great idea.
Great.
If
Yeah, and then I
Right.
think the other thing that we could do too is have we could have a second look or third look at another draft of the standards before with the language that we're talking about before it comes up for vote. I think, and we'll have another work group before the August meeting as well. So we'd have one commission meeting, one work group meeting, and we'd have input from providers. And I like that idea.
Steve, the version that would go out for the comments would be the newest version.
We would have to add some language that we've talked about here today,
Yeah,
but it would be based on the most recent version. Yes, ma'am.
with that language added.
Yes.
That sounds great.
Yeah, perfect.
Yeah. Okay, that sounds good. Let's do
Yeah.
that.
All right.
Okay, is that all right with you, Steve? Sorry. Also, we're not really making, I should also say, we can't really make decisions here. We're just suggesting things to you that you might want to do.
No, I think the language is great. If we're worried about PCR, we should have some language about that. I think it's important to let people know that they are no less competent under new standards than they were under old standards.
Yeah.
These are all, I think they're great ideas.
Great, okay, thank you.
Great.
Philippe, I thought I saw your hand up.
Yeah, I was just going to add that I thought that new language seems to have, pretty wide consensus. It seems kind of like a no-brainer that we don't want to have people, be having to reprove what they're already doing. So things to make that clear within the standards, I think, is going to be welcomed by providers.
Great, okay. Wonderful. So the other thing that was on the agenda is talking about the question and answer session, but I'm actually not, we shouldn't do that. And that's because Susan and I've already talked about it, and we were hoping to get kind of a lot more input, and just Philippe is here who doesn't even know what we're talking about. So, we'll just table that for the next work group to talk about how we want, and we already have our next question submission for July. So we'll table that for our next work group and have a chat with the broader commission about how we want to go forward. We had a new thing in June that we did that we really liked, where we posed a series of questions and then had people answer them. And we had a panel. Our meeting in June was in person, and we had a panel of people that came up and kind of gave presentations that answered the questions. And we had a more back and forth dialogue, which all the commissioners found to be really helpful. So the idea is to talk about how we want to do that for virtual meetings and how we want to do that going forward. So we can do that at another time. And it's 5:40, and that's, unless there's anything else that anyone else wants to talk about, we can send Ken off to his kid's baseball game. All right. Thanks, everybody. And we'll see you in a couple of weeks at the meeting in July.
Thank you all.
Thanks.
Thanks, everyone.
Bye.
Bye.
Bye.